Hello, I'm Brenna Baye, the head of the construction team here at Edwin Co. Edwin Co.'s construction team deals with all manner of both contentious and non-contentious construction work, acting for both individuals and companies. Currently, the sector is undergoing radical change following royal assent of the Building Safety Act in 2022. Intended to address the failings laid bare by Dame Judith Hackett's scathing review of the building regulations and fire safety following the tragic events at Grenfell Tower, the Act imposes extensive changes for the industry as a whole, and in particular in relation to higher risk buildings. Today, I want to talk about the changes in the building control regime which impact higher risk buildings. Although much of the focus since Grenfell has been on the defective cladding, from her review, Dame Hackett found that the regulatory system for safely designing, constructing, and managing buildings was not fit for purpose, resulting in the birth of the Building Safety Regulator, or BSR. Part of the Health and Safety Executive, the BSR has two objectives: securing the safety of people in and around buildings in relation to risks from buildings, and improving building standards. To accomplish these objectives, the BSR is responsible for implementing a new, more rigorous yet proportionate regulatory regime for higher risk buildings. As such, the BSR is now the building control authority for all higher risk buildings in England. This means that a developer can no longer choose between a local authority or an approved building inspector where they are developing a higher risk building. To ensure the BSR is engaged from the outset of a project, there is now a gateway regime to provide strengthened oversight and rigorous inspection of building regulation requirements before, during, and on completion of building work. The three gateways, which are mandatory hard stops at planning, during design and construction, at completion, and then preoccupation, apply to both new and major refurbishments of existing higher risk buildings. So for example, where buildings are currently seeking funding from the Building Safety Fund or are being remediated by their original developer, they will, depending on their height, need to follow the new regime. I want to focus today on gateways 2 and 3, given the impact they will have on building contracts for higher risk buildings. Gateway 2 replaces the old deposit of full plan stage of the building regulations and is a stop and go point such that building control approval must be obtained from the BSR before any work commences. To address situations where developers had begun elements of works or were about to commence, there has been a transition period in place for Gateway 2 since the 1st of October 2023. What this means is that where a project had either submitted an initial notice, which had not been rejected, or had full plans approval by the 1st of October 2023, it could continue based on the old building control regime. However, the transition provisions are subject to works being sufficiently progressed by the 6th of April 2024. The nature of the works will determine what is deemed sufficiently progressed. If this threshold is not met, works must immediately cease and an application must be made to the BSR. The timeframes for the BSR to determine an application are 12 weeks from the date of an application for a new building and 8 weeks for an existing building. However, anecdotal evidence is that these timeframes are in fact prolonged given the newness of the regime. Since works cannot commence without BSR approval, and contractor involvement is required to collate the information required for a Gateway 2 application, one can easily see that parties need to consider their procurement routes, the result of which is that we are seeing an increased use of pre-construction services agreements for the Gateway 2 process. Another aspect of the new regime which needs to be considered by contracting parties at the outset is the concept of controlled changes. Notifiable changes must be notified to the BSR before the work relating to that change starts, while any major change requires an application to be made to the BSR for building control approval, with no work to be carried out relating to that change until approval is granted. The legislation provides detailed examples of both notifiable and major changes, but by way of a few examples, notifiable changes include changes to the layout of a flat, either in a proposed or an existing higher risk building, changes to the number or dimensions of any of the openings in the walls, ceilings, or other building elements for any pipe, duct, or cable, or any other change to the fire and emergency file or the fire safety compliance information. Major changes include, but are not limited to, a change to the structural design or structural loading of the building, a change to the number or width of the staircases, or a change which increases or decreases the external height or width of an existing higher risk building. Again, these are not exhaustive lists, and the time frame for the BSR decisions on major changes is indicated as being 6 weeks. Yet, what if the BSR's decision is delayed? Is it the contractor or the employer's risk? The other key area, which will heavily impact contracts for higher risk buildings, relates to Gateway 3. On completion of the works, a completion certificate application needs to be made to the BSR, which assesses the application, carries out a final inspection of the works, and, if satisfied, issues a completion certificate. The BSR has 8 weeks to determine a completion application, and it is an offence for a building to be occupied without a completion certificate. So how should practical completion under a building contract now be determined? Typically, PC requires building control sign-off. Yet, under the new regime, this could take at least 8 weeks, potentially more. Should a contractor be programming for this? If there is a delay due to the Building Safety Regulator, is it right that the contractor might be liable for liquidated damages? What if the application is rejected by the BSR? Is that the contractor's or the employer's risk? It is clear that the new building control regime requires developers and contractors to have detailed discussions regarding a project well in advance of entering into any contract. As previously mentioned, it is likely that pre-construction services agreements will now become more prominent as parties work together to make the Gateway 2 applications. As well, detailed consideration must be given to what occurs if changes are required during the course of the works, as well as how to deal with the Gateway 3 application and practical completion. There is little doubt that the Building Safety Act is the most transformative piece of legislation for the construction industry in over 20 years, and that as a result of the Act, the days of commencement on site without a contract are truly over. Edwin Co.'s construction team is actively engaged on a number of projects which are dealing with these issues and their implications to the building contract. So if you need any assistance with your project, please do get in touch.